Very good afternoon to all of you, and welcome all of you in the today's second session, contact session, which is on subject business law. Today we got the faculty for this subject, Dr. Sushant Mane sir, who is also associated with Center for Distance and Online Education, Shivaji, Kolhapur, who have a good amount of teaching experience and also having a good knowledge in the subject of law. So I warm welcome to Professor Dr. Sushant Mane sir from the on the behalf of CDOE Kolhapur. I also welcome all the students who are attending to this second session. This is a recorded session, so who are not online now, they can listen the lecture after two times on the YouTube live, which is link shared on the WhatsApp group. So I request to Mani sir to start the session. Thank you. Thank you so much.
Thank you, Kamlakar sir. I welcome to all the MBA students who got the admission for MBA Part 1, Semester First. I'm Dr. Sushant Vimani, your teacher for MBA for the subject of business law. Today we are going to start first unit, that is law. I will share you uh, PowerPoint presentation. With the help of PowerPoint presentation, we will discuss the unit number first, that is business law. Just a minute. Okay, friends, before going to open the PowerPoint presentation, we will introduce what is law. The law affects every aspect of our lives. It governs our conduct from the cradle to the grave, and its influence even extends from before on birth and after our death. Law is essential to any society in that it provides the rules by which people and businesses are interacted between each other. Law affects almost every function and area of the businesses. So now the what is law? The law is a set of rules enforceable by law, by the courts, which regulate the government of the state and govern the relationship between the state and its citizens, and between one citizens and another citizens. So basically, the law is a rules made by the authority for the proper regulation of a community or society, or for correct conduct in the life. This is the basic terminology of the law. which is helpful for the every and each business activities. So what is the nature of law? Law is at one and the same time essential, authoritative, and essential ideal. So the law necessarily comprise both a real or factual and an ideal or critical dimension. A central element of its ideal dimension is a claim to correctness, which includes a claim to moral correctness. A central element of the real dimension of law is coercion or force. Okay, the Constitution of India is the supreme law of India. It is the longest written constitution of any sovereign country in the world. So it come into effect on 26th January 1950. Have you seen the PowerPoint presentation on your screen? Hello, anybody?
No, sir.
No,
No,
sir.
sir.
Have you not seen?
No, sir.
No,
No,
sir.
sir.
Just a minute. Now, have you seen?
No, sir.
No, sir.
Wait for some time because the law is a very critical subject to understand smoothly, but without a PowerPoint presentation, you may not understanding the concepts. What is exactly? Just wait. Have you seen now
Yes, sir.
PowerPoint presentation?
Yes, sir. Yes, sir.
Okay. Okay. As you are go through the syllabus contents of unit first or all the paper, so we will not discuss here about the syllabus. That is first part is Indian Contract Act 1872 and the second part is B Sales of Goods Act 1930. So the focusly we are going to discuss on the business law, that is its definition and meaning. So what it here we see, the business law is a crucial component of a law in general sense. Without it, the corporate, manufacturing, and retail sectors would all be under the dictatories, uh, dictators rules. So combining the business and the law seeks to create a secure and efficient working environments for everyone associated with the businesses. So basically here we can say that the combination or a set of business activities and the laws is combinedly together and it comes to the business law. So the definition what it is say, business law also known as a commercial law or corporate law is the body of legislation governing the rights, relationships, and behavior of businesses and individuals engaged in commerce, merchandising, trade, and sales. It deals with the both private and public law issues and is sometimes seen as a branch of civil law. So basically, what they have given here, the all the activities that is comes under the commerce and merchandise trade and sales, which is a business activities, and the governing by the laws, which is commercial laws or corporate laws, are there. So they are run with the help of that commercial laws or corporate laws, which is a business law. That is the basic definition given by the some authors here. So now we will discuss about the why business law is necessary. So here they are given, every successful organization needs to grab business laws to compete in the market. So the corporation require a staff of attorneys with this degree to handle the legal aspects of their operations. So we can say the different kinds of operations done in the businesses, that operations have to be uh, uh, taken into handle by the uh, uh, basically a compliance officers, that is law officers are there. So additionally, a person with a degree in a business law can develop more sensible policies than the others, because they build the framework while considering the market and the effects of governmental rules and regulations on that market. A professional with through thorough knowledge of businesses law can help the company to avoid the legal issues which is occur in the business activities. So which now a company wants to deal with, that some issues occur in the businesses. Now the advantages of business law. What are the advantages of business law? The legal agreements and contracts is the one of the major advantage given in the business law. Then the understanding the business rules, then take charge of your own, then compensation concern, then protect shareholders' rights. Now you know about the how the businesses raising their funds and their capitals through the share market. So the responsibility of the businesses is that what the how to protect the shareholders' rights and how to protect their monies that invested by the shareholders. So that kind of advantage take by the shareholders with the help of that business laws. Then the last one is business formations. How and when and where the business is formed, that kind of also steps given by the business laws. So with the help of this, the business law is advantages given to the any business activities. Now the characteristics of business law. Defining general rules of commerce. The various business entities and corporations and companies are comes under the commerce because they are producing something and given the services to the customers and any others. So for that, the primary general rules have to be formulated by the business laws to run the commerce industry, which is comes under the business laws. Now, the second one is protecting business ideas and business assets. Here we will see here protect shareholders' rights. Again, protecting business ideas and business assets is also one of the major characteristics given of a business law. Then providing mechanism that allow business people to determine how they will participate in the businesses ventures and how much risk they will take bear. That also one of the feature given by the business laws. Then ensuring that losses are borne by those responsible for causing them and facilitating planning by ensuring that commitments are honored. These are the some important features or characteristics of a business laws which will helpful for the any business entities or business concerns. Okay, now we'll go for the sources of business law. There are five major sources have been drawn here in India, that the statutory law, English mercantile law, then case law, then precedents and Indian statute law. The main sources of business law in India are one statutory law. In respect of statutory law, we can say that legislation and statutory is the most important source of law. So the legislation is the making law, but when we use the term legislation as a source of law, we mean law making by the statutory authorities. By both the parliament and the state assemblies have enacted the some number of legislations that cover various aspects of businesses. In England, a distinction is made between the statutory law and written law and the common law. These are the three common factors are there of the laws, that statute law, written law, and common law in England. Only the former is called as legislation. But in India, there is no common law. Here, legislation and enacted law is different from the customary and personal law. So, statutory law is one of the major source of the business laws, which is implemented and adopted by the government of India. Then, one of the second sources of business law is English mercantile law. So, the English mercantile law constitutes the foundation of which the supreme structure of the Indian mercantile law has been built. So our Sales of Goods Act, for instance, has been taken from the English Sales of Goods Act, which is framed by the Britishers. So even now, despite of the enactment of various statutes relating to matter falling with the purview of mercantile law, our courts generally take such sources to the English law, where some principles are drawn expressly dealt with the act, or where there is ambiguity. So English mercantile law is one of the major source of our business law or any other law which is taken from the English laws. So this is one of the major source of business law. Now the third one is a case law. Case law, popularly called as a president law by lawyers, is a judgment of a superior court, including a point of uh, principles and which necessitates its adoption and adherence in a subsequent case involving the same point. Case law is a useful in a as much as it helps courts to render the uniformity with the regard and to the interpretation of the statutes. So the case law is also one of the major source which is taken into consideration while discussing about the major or main source of a business law. So we can say that the different kinds of courts have been given some of the results, and with that results the law will be amended in the future. So the fourth one is a precedents. Past judicial decision in common law legal system, a president or authority is a legal case that established a principle or a rule. The principle or a rule is then used by the court or other judicial bodies use when deciding later cases with similar issues or facts. Here we can similarly see about the case law and precedents. In case law also there is some issues and facts are similar. So the judicial bodies have been decided the earlier studies or earlier cases which is finalized by the court, that will be considered for the again future amendment of the business laws or any acts or any sections drawn in the future. So this is the same case law and the precedents, which is one of the major source of the business law. Now the last is the Indian statute law. Statutory law or a statute law is a written law set down by the body of a legislature or by a singular legislator in the case of absolute monarchy. So this is as a opposite to a oral or customary law or a regulatory law promulgated by the executive or a common law of the judiciary. So the statutus may be originate with the national state legislature or a local municipality. So this kind of Indian statute law also is a one of the source of a business law, which is considered into the business law. We can say here की आपण काय म्हणतो बघा मित्रांनो की लोकल म्युन्सिपालिटीज असतील किंवा नॅशनल लेवलला किंवा स्टेट लेजिस्लेचर असतील तर यांच्यामधून सुद्धा काही नियम किंवा काही कायदे बनवले जातात की ज्याच्यातून काय केलं जातं की त्यांना त्या पद्धतीनेच त्याचा व्यवसाय चालवावा लागतो. फॉर एक्झाम्पल घेतलं तर आपल्याला एखादं जर छोटंसं जर दुकान किंवा एखादं छोटं जर शॉप जर सुरू करायचं असेल एखाद्या शहरामध्ये की ज्या ठिकाणी म्युन्सिपाल्टीज असतील लोकल बॉडीज असतील तर त्या ठिकाणी काय करावं लागतं की म्युन्सिपाल्टीजचं तुम्हाला लायसनिंग घ्यावं लागतं. That is one of the kind of a law that which implemented by the local bodies or state legislatures. So this kind of the sources of the business law. So now we will discuss about the nature of business. It is a conduct and a culture, tradition, and religion developed by humans. So, according to the culture and religion and their traditions, the business laws has been developed by the humans. So, this is one of the one nature is given in the business law. So, second one is it creates rights and duties. So, after the making the business laws or acts, they are creating some of the rights and duties for the both the parties. So it ensures all the people have specific power and responsibility. Along with the rights and duties creating, the people are having some specific powers and responsibilities also ensuring by the business law. So it maintains peace and security. So after the following the business law and their all the acts and the all the uh, uh, given the procedure of the law, the maintaining the peace and security in the businesses. So it is one of the nature of the business law. So it's provide justice and administrator punishment. So if there is any injustice is happened with the help of this business law, every business concern can take the justice from the court and against the parties they can apply or avail the punishment regarding the any case. It always aims to give justice to the victim and punishment to the law of breakers. म्हणजे काही असतात बघा समाजामध्ये की जाणून बुजून कायद्याचं उल्लंघन करण्याचं कार्य करत असतात. तर अशांच्या मधून काय आहे की त्यांना न्याय मिळवण्याचं कार्य सुद्धा या ठिकाणी बिझनेस लॉ मधून दिले गेलेले आपल्याला सांगता येऊ शकेल. देन इट रेग्युलेट्स डे टू डे ऍक्टिव्हिटीज. सो वी कॅन से दॅट द बिझनेस रनिंग विथ द help of the business laws. So the day-to-day activities happened in the businesses or any organizations or any companies, it will be regulated by the business laws. So regulates internal activities also done with the help of business laws. So defined by the these all the defined by the Supreme Courts. So with the help of this, we can conclude this nature of business law. There are some scope of business laws. Now you are observing on your screen that the constitutional law is there, some of the criminal law is there, civil law is there, industrial law is there. Whenever the industrial dispute is there, the industrial law will be helpful for the businesses. Again, the labor law is there, which is helpful for the laborers. Whenever the any kind of labor disturbance or labor any kinds of issues are there, the labor law is helpful for the businesses. Then commercial law is there. Then MRTP Act is there 1969. That is monopolistic restrictive trade practices is in the business activities. So the monopolistic restrictive trade practices act is also passed by the government in 1969. It is also is a scope of the business law. Then Environmental Protection Act 1986 is there. Some of the companies or organizations having a production line and manufacturing line, with the production and manufacturing, the environmental issues and environmental problems are occurred. With the help of the Environmental Protection Act, they are solving this kind of issues. Then the Patent Act is there, 1976. SICA Act is there, 1985. Then the Protection Act, 1986 is there, which is helpful for the scope of the business law. Then we will go to the next. The classification of contracts. So here we will discuss about the Indian Contract Act 1872. So the major part of that, the classification of the contracts. So here we will see the on the basis of some of the contracts, on the basis of validity, then the some of the on the basis of a formation, and on the basis of performance. So one by one we will discuss about the what kind of contracts are there in the Indian Contract Act. So on the basis of validity, what it see we valid contract. So what is valid contract? A valid contract is an agreement enforceable by law. An agreement becomes enforceable by law when all the essential of a valid contract as laid in the section of 10 are fulfilled. So under the Indian Contract Act section 10, some essential elements are there. After the fulfillment of that essential elements, the contract will be valid. So this kind of a contract is valid contract. So next one is a void contract, an agreement which is legally enforceable when entered into, but which has become void due to supervening impossibility of the performance. For example, we can say a contract between the citizens of the Pakistan and India is a valid contract, but during the peace it is valid. But if the war breaks out, then between the two countries, the agreement will become a void contract. So, फॉर एक्झाम्पल आपल्याला वाईड कॉन्ट्रॅक्ट काय म्हणायचं आहे की या ठिकाणी इंडिया आणि पाकिस्तानमध्ये असणारे जे वेगवेगळे बिझनेस आहेत ते काय करू शकतात, अग्रीमेंट करू शकतात, कॉन्ट्रॅक्ट करू शकतात. पण ज्यावेळी काय आहे पीस म्हणजे काय शांततापूर्ण वातावरण असेल त्यावेळी तुम्ही काय करू शकता, कॉन्ट्रॅक्ट करू शकता. बट वेन द वॉर इज डिक्लेअर्ड you cannot make the contract, and if it is made, it is void. That kind of a nature of a void contract. So now we will go for third, unenforceable contract. It is a contract which is actually valid but cannot be enforced because of some of the technical defect is there, such as nothing in a writing or understamped. Such contracts can be enforced if the technical defect involved is removed. For example, an oral agreement for arbitration is enforceable because of the law requires that an arbitration agreement must be in written. It is the oral agreement for the arbitration. It is reduced to written. It will be come enforceable. सो फॉर एक्झाम्पल आपण काय म्हणू शकतो बघा की अनइन्फोर्सेबल कॉन्ट्रॅक्ट काय आहे की त्याच्यासाठी असणाऱ्या ज्या कंडिशन्स आहेत त्या कंडिशन्स काय आहे, टेक्निकल इफेक्टमुळे जर करता येत नसतील तर काय करू शकतो, त्या ठिकाणी तो कॉन्ट्रॅक्ट होऊ शकत नाही. फॉर एक्झाम्पल दिलेलं आहे बघा की स्टॅम्प लागतो, म्हणजे आपल्याला माहित असेलच की कोणताही कॉन्ट्रॅक्ट करायचा असेल तर स्टॅम्प ड्युटी भरावी लागते. इट शुड बी enforceable by the law. So that kind of a unenforceable contract is there, which is comes under the basis of validity. Then the illegal agreements. An illegal agreement is one of the object of which is unlawful. Such an agreement cannot be enforced by law. Thus, illegal agreements are always void ab initio, which is what we can say void from the very beginning. Thus, a contract to commit dacoit is an illegal contract and cannot be enforced by the law. This kind of also agreement is there, which is helpful for the business law. Then next one is on the basis of formation. So there are four contract is there which is given in the business law, that is express contract, implied contract, constructive or quasi contract, then e contracts and contracts over internet. These are the four contracts comes under the formation of formation. So express contracts, what it means? Express contract is one of the contract which is made by the words spoken or in written. That is express contract. Now the second one is what? Implied contract is where the proposal or acceptance is made otherwise than the words. It is an implied contract. Implied contracts can be smelled out of the surrounding circumstances and the conduct of the parties who made them. For example, a transport company buses on the different routes that carry passengers. This is an acceptance by the passengers. Now this will be the implied contract. So this kind of a contract is a implied contract. Now the next one is a constructive or quasi contract. It is a contract in which there is no intention or either side to make a contract, but the law imposes a contract. In such a contract, right and obligations arises not by any agreement between the parties by operations of laws. Thus, a finder of lost goods, similarly, where certain books are delivered to the wrong addresses under the obligations either to pay for them or return them. That kind of quasi contracts. Now the last one is a e-contracts or contracts over the internet. Now these contracts are entered into between the parties using some of the internet websites. In electronic commerce, different parties create networks which are linked to other networks through we can say EDE, that is electronic data interchange. This helps to doing businesses transactions or using electronic mode and happening or done the contracts. So this kind of four contracts are on the basis of formation. Now we will discuss on the basis of performance. There are four also given the types of on the basis of performance, that is executed contract, executory contract, unilateral contracts and bilateral contracts. So what is executed contract? It is a contract where both the parties to the contract have fulfilled their respective obligations under the contract. So both the parties have been completed their obligations or their duties or their responsibilities. That is executed contract. What we can say, for example, A sells a TV set to the B party for 20,000. So B paid a price of 20,000 to the A. That is fulfilled uh, contract. So it is also called as a executed contract. Now the executory contract, it is a contract where both the parties to the contract have still to perform their respective obligations or responsibilities which will decided by the both of them. For example, A agreement to make furniture for B for 5,000. Mr. A has yet to make a furniture and B has not made the payment. So both the A and B are yet to perform their obligations. So in this case, we can say the intention or the object of the contract is not fulfilled. So it is executory contract is called. So the next is unilateral contract. So a unilateral contract is one of in which a promise on one side is exchanged for an act on the other side. For example, Mr. A worker does manual labor at the request of the Mr. B on a particular day on completion of work of its B obligations to pay him wages because A has already performed his obligations. So this kind of unilateral contracts is there. Then bilateral contract, these are the contracts where a promise on one side is exchanged for a promise on the part of the other side. So this kind of parties are there, and the contracts have been made by the both the parties. So this is the classification of the contracts, which is very essential with the help of completed business laws. For your examination, it is one of the best questions asked by the university, that is, what are the classification of the contracts, so you can understand smoothly these concepts. Now according to the section 2 H Indian Contract Act 1872, the contract is an agreement enforceable by law or at law. So what is agreement? Agreement is equal to offer plus acceptance. So if the proposal is given by the any one party and the acceptance will be taken, it will become a agreement. So what is contract? The contract is equal to agreement plus enforceability by law or at law. So after the agreement is made, the agreement is converted into the contract with the help of enforceability of the law. So the contract must have been some of the essential elements is there, and that will be fulfilled by the both the parties, and that is also only enforced by the law. So an agreement to be enforceable by law must possess the essential elements of a valid contract as contained in the section 10 of Indian Contract Act 1872. Only that agreements which are enforceable by law are contracts. So here given directly that agreements which are enforceable by law are only the contracts. All contracts are agreements, but all agreements are not contracts. So this you will understand what they are given the statement, which is a very important regarding the Indian Contract Act. What they said, contract are agreements, but the all contracts are not, but the all agreements are not contracts. So that is very important. Now, some of the essential elements of the valid contract we will see. The first is one of the offer and acceptance. In order to create a valid contract, there must be a lawful offer by one party and a lawful acceptance by the other party. So section 2A of the Contract Act defines what is offer. When a one person signifies to another his willingness to do or to absent in from doing anything with a view to obtaining the assents of that other to such a act or absentance, he is said to make an offer. सो सिंपल एक अशी डेफिनेशन दिलेली आहे की ऑफर काय असणार आहे, तर त्याची एक डेफिनेशन आहे. इट इज व्हेरी critical to understand, but you should memorize that definition, which will helpful for your examination point of view. So second one is section 2B of the Contract Act. When a person to whom the offer is made signifies his assent thereto, the offer is said to be accepted. So offer and accepted given by the definitions given by the Indian Contract Act 1872. Now the second is competencies of the parties and capacities of the contract. The parties to an agreement must be competent. If either of the parties does not have the ability to contract, the contract is not valid. That is void contract. So the following persons are the incompetent to the contract. As per the Contract Act 1872, some of the conditions are given, and that conditions are: first one is a minor, a person less than age of 18 is a minor. So आपल्याला माहितच असेल की 18 वर्षाखालील जी काही व्यक्ती असेल त्याला आपण काय म्हणतो, तो अज्ञान आहे असं आपण या ठिकाणी कन्सिडर करतो. सो अज्ञान जो असेल तो काय करू शकत नाही, कोणत्याही प्रकारचा ॲग्रीमेंट किंवा कॉन्ट्रॅक्ट करू शकत नाही बाय द लॉ. So second one is a unsound mind person. Any person who is unable to understand the term and conditions of a contract at the time of its formation is an unsound mind. So आपण काय म्हणतो की अज्ञान म्हणजे की ज्या व्यक्तीची शुद्धता नाहीये, म्हणजे तो व्यक्ती काय आहे, बुद्धीने सक्षम नाही की त्या कॉन्ट्रॅक्टमधील काही जे टर्म्स अँड कंडिशन्स असतील किंवा ज्या अटी किंवा शर्ती असतील समजावून घेऊ शकत नाही, तो व्यक्ती काय असू शकतो या ठिकाणी अनसाउंड माइंडचा पर्सन असू शकतो असं म्हटलेलं आहे. आणि तो या ठिकाणी त्या कॅपॅसिटीमध्ये कॉन्ट्रॅक्ट करण्याच्या बसू शकत नाही. देन थर्ड वन इज अ पर्सन डिस्क्वालिफाईड बाय लॉ टू विच दे आर सब्जेक्ट. पर्सन डिस्क्वालिफाईड बाय लॉ, असं एखादं उदाहरण तुम्ही कोण सांगू शकता का की ए पर्सन डिस्क्वालिफाईड बाय द लॉ इन इंडिया? एनीवन कॅन? हॅलो हॅलो
गुन्हेगार असलेला पर्सन.
गुन्हेगार असलेला. व्हेरी नाईस. एनी अदर? एखादा तुरुंगवास शिक्षा बघत असेल तो व्यक्ती या ठिकाणी काय असतो, तो डिस्क्वालिफाईड असतो. एनीवन अदर?
NRI, इंडिया बाहेरचा व्यक्ती.
No, here the NRI is made the contract. There is no problem. In the earlier we will discuss that the person who is located in the Pakistan, he will
Okay,
make the contract with us in India. But the condition is what? If the war is break out, suppose काय युद्ध जर डिक्लेअर झालं असेल तर त्या ठिकाणी काय
हा.
करू शकत नाही, तो व्यक्ती येणार आहे काय करू शकत नाही, कॉन्ट्रॅक्ट करू शकत नाही. पण एखादा येणार आहे अशा ठिकाणी आहे, सपोज अमेरिकेमध्ये आहे किंवा ऑस्ट्रेलियामध्ये आहे, जपानमध्ये आहे, तर तो काय करू शकतो, या ठिकाणी आपल्याशी कॉन्ट्रॅक्ट करू शकतो. देर इज नो प्रॉब्लेम. एनी
Okay.
अदर? काही व्यक्तींची नावं सांगू शकता का, पर्सन्स डिस्क्वालिफाईड बाय लॉ?
मेंटली डिसऑर्डर असणार व्यक्ती.
येस, मेंटली डिसऑर्डर्ड व्यक्ती सुद्धा करू शकत नाही. राईट. लुक ॲट, तुम्ही काय आहे की समजावून घ्या कॉन्सेप्ट काय आहे. कारण वेन यू आर गोइंग टू अटेम्प्टिंग द एक्झाम, यू कॅनॉट रिटर्न समथिंग इन द कॉम्पिटन्सीज ऑफ द पार्टीज ऑर कॅपॅसिटीज ऑफ पार्टीज. मला या गोष्टी समजावून घ्यायला लागतील तरच तुम्ही पेपरमध्ये काहीतरी लिहू शकता. बिकॉज इट इज इम्पॉसिबल टू मेमोराइज एव्हरीथिंग अँड इच अँड एव्हरीथिंग. ओके. तर तुम्हाला एक दोन व्यक्तींची नावं सांगतो बघा. नीरव मोदी माहीत असतील तुम्हाला,
येस सर.
आणि एक आहेत बघा किंगफिशरचे विजय मल्ल्या असतील. That
हो.
kind of persons are disqualified by the law in the our country. So these kind of persons are not making any kind of a contract with the any persons in the India. So या ठिकाणी काय झालेलं आहे, कॅपॅसिटी काय केलेली आहे त्यांची किंवा कॉम्पिटन्सी जी काय आहे त्यांच्याकडून काढून घेण्यात आलेली आहे बाय द बिझनेस लॉ. ओके. सो वी विल गो फॉर नेक्स्ट, the free consent. Okay, the consent means the parties must have agreed upon the same thing in the same sense. According to the section 14, consent said to be free when it is not caused by some of the given here portion असेल, undue influence असेल, फ्रॉड असेल, मिसरिप्रेझेंटेशन असेल किंवा मिस्टेक असेल. तर या 4-5च्या मध्ये काय आहे की फ्री कन्सेंट आहे असं दिसून येत नाही. त्यामुळे an agreement should be made by the free consent of the parties. Both the parties must have to be free consent, and then only काय होऊ शकतं, the contract will be completed or fulfilled. So free consent should be there while you are making the agreement or making the contract. So this is the one of the essential condition given by the Indian Contract Act while making the contracts. So the next, lawful object is there. The object of an agreement must be valid. Object has nothing to do with consideration. It means the purpose or design of a contract. Thus, when one hires a house for a use of as a gambling house, the object of the contract is to run a gambling house, the object is said to be unlawful. म्हणजे तुम्हाला माहितीच आहे की अशा पद्धतीचे काही जर ऑब्जेक्ट जे काय असतील अनलॉफुल असतील, तर अनलॉफुल असल्यामुळे काय आहे किंवा बेकायदेशीर असल्यामुळे काय आहे, या ठिकाणी कॉन्ट्रॅक्ट हा कम्प्लीट होऊ शकत नाही. त्यामुळं ऑब्जेक्टिव्ह ऑफ द कॉन्ट्रॅक्ट और अग्रीमेंट इट शुड बी enforceable by law, or it should be implemented, or it should be not given any issue or any problem to the anyone. Okay, then the here some of the given example of the or enforceable by law. It is forbidden by law, then it is a such a nature that if permitted it would be defeat the provision of any law. It is fraudulent, then it involves an injury to the person or a property of any other. The court regards it is an immoral or opposed to the public policy or any agreement to the distribute the money earned by robbery. जे काही या ठिकाणी लॉफुल ऑब्जेक्ट म्हणजे उद्देश जो आहे कॉन्ट्रॅक्ट करण्याचा किंवा अग्रीमेंट करण्याचा, तो कसला पाहिजे, कायदेशीर असला पाहिजे, एवढा हेच या ठिकाणी काय आहे सांगण्यात आलेलं आहे. ओके, then we go for next, certainty of a meaning. According to section 29 of Indian Contract Act, agreement the meaning of which is not certain or capable of being made certain or void. For example, here given A agree to sell to B a 100 ton of oil. There is nothing to show what kind of oil is intended. Okay, so the agreement is void due to the absence of the certainty. But if A is declared that the coconut oil only agreed to sell B 100 tons of oil, the nature of the A's trade is sufficient to show the kind of oil. So this will be the valid contract. म्हणजे या ठिकाणी काय आहे की ज्या गोष्टीसाठी तुम्ही काय करत आहात की कॉन्ट्रॅक्ट करत आहात किंवा ॲग्रीमेंट करत आहात, तर त्याची सर्टन्टी जी आहे ती सर्टन्टी काय झाली पाहिजे, डिस्क्लोज झाली पाहिजे, या ठिकाणी ते अपेक्षित आहे. तर अशा पद्धतीची एक एलिमेंट सुद्धा काय आहे कॉन्ट्रॅक्ट करत असताना किंवा ॲग्रीमेंट करत असताना एसेन्शियल असलेलं आपल्याला सांगता येऊ शकेल. Then possibility of a performance, conditions for a contract should be capable for the performance. If the act is impossible in say itself physically or legally, if it cannot be enforced by law, it not possible as per the contract act. For example, here given, if A and B makes an agreement that if B encloses a space with the help of two straight lines, then A will pay him 1,000. Otherwise, B will liable for paying rupees 500 to A, which is resulting that this is an impossible work. Two straight line cannot be enclose a space, hence contract is not valid. तर अशा पद्धतीचं काय परफॉर्मन्स म्हणजे काय आहे की तो पॉसिबल असला पाहिजे. तर पॉसिबल असेल तरच काय करू शकता तुम्ही तो कॉन्ट्रॅक्ट किंवा ॲग्रीमेंट करू शकता. सो इट इज वन ऑफ द नेसेसिटी ऑफ ए कॉन्ट्रॅक्ट ऑर ॲग्रीमेंट. Then not declared to be void or illegal. The agreement, through satisfying all the conditions for a valid contract, must have been expressly declared void by any law enforced in the country. Agreements mentioned in the section 24 to 30 of the Indian Contract Act have been expressly declared to be void. For example, agreements in restraint of trade, marriages, and legal proceedings, etc. Is there. Here one of the example is there, if A is not willing to marry with B, law cannot be enforceable to him or her. So that kind of also elements is there. Now legal formalities is there. An oral contract is a perfectly valid contract, except in those cases where writing, registration, etc. is required by the some statute. Now we will discuss about the some statute in India. Written is required in case of sale, mortgage, lease, and gift of immovable property, negotiable instruments. Some of the memorandum is there, articles of associations of a company is there, etc. Registration is required in case of documents coming within the scope of section 17 of Registration Act 19 not 8. All the elements mentioned above must be ordered to make a valid contract. For example, here we will see the mortgage. If you want to some loan from the any public, private or cooperative sector banks, so you must have to give the some property against that loan. So the mortgage will be the contract between the bank and the loan holder. That kind of a agreement is there. So here the legal formalities should be completed by the both the parties is necessary. So next, void and contingent agreements. So what is void agreements? Section 2G of the Indian Contract Act defined a void agreement as an agreement not enforceable by law. Some agreements are void ab initio, which is what void from the beginning, which means that they are in unenforceable right from the their time of their made. For example, here given the you learned that the agreement with the minor or a person who is unsound mind is a void ab initio. ठीक आहे की सुरुवातीपासूनच जे काय असेल ते जो वाईड ठरवला गेला असेल ऍज पर द सेक्शन 2G ऑफ इंडियन कॉन्ट्रॅक्ट ऍक्ट तो काय या ठिकाणी व्हॅलिड कॉन्ट्रॅक्ट होऊ शकत नाही. देन सच अग्रीमेंट डज नॉट बिकम ए कॉन्ट्रॅक्ट ॲट ऑल दिलेलंच आहे या ठिकाणी. they are may however be some agreement which are when made are enforceable. They are contracts, but later due to some development of a certain circumstances or changes in the what we can say possibilities, it becomes unenforceable. When they become unenforceable, they are called as a void contract. So this kind of a contract is also there. So the next is here some of the agreements that expressly have been declared that they are void, always void. So these are the agreements by or with the person of incompetent to contract. Section 10 and 11 is given there in Indian Contract Act. That is, the person is competent, incompetent असेल तर तो काय करू शकत नाही, agreement करू शकत नाही. Then the section 20 says that the agreements entered into through a mutual mistakes of a fact between the parties. Some of the mutual mistakes are done in the contracts, and then the agreements will be void. Then again, section 23. Indian Contract Act, given the agreement, the object and consideration of which is unlawful. In here, object is also very important, which is lawful. So if the object and consideration is not comes under the lawful, it is a void contract. So then a consideration and object which is a partly lawful. म्हणजे या ठिकाणी काय आहे की ऑब्जेक्ट जे आहे उद्देश आणि कन्सिडरेशन म्हणजे काय म्हणू शकतो आपण प्रतिफल किंवा मोबदला जो आहे काय तिथे त्या दोन्हींना काय आहे लॉफुल अनलॉफुल का बनवलेलं आहे कारण त्या दोन्हींची काय आहे पूर्तता ही दोन्ही पार्टींनी करणे या ठिकाणी आवश्यक आहे. ॲग्रीमेंट मेड विदाउट कन्सिडरेशन इज अ void कॉन्ट्रॅक्ट. एक नेहमी लक्षात ठेवा कोणतंही ॲग्रीमेंट असेल तर त्या ॲग्रीमेंटमध्ये किंवा त्या कॉन्ट्रॅक्टमध्ये कन्सिडरेशन म्हणजे मोबदला म्हणजे त्या ठिकाणी पैसे असू शकतात किंवा काही वस्तू असू शकतात किंवा काही सर्व्हिसेस असू शकतात. ह्या असल्याच पाहिजे तरच तो काय होऊ शकतो ॲग्रीमेंट किंवा कॉन्ट्रॅक्टमध्ये रूपांतर होऊ शकतो. या ठिकाणी दिलेलंच आहे की ॲग्रीमेंट मेड विदाउट कन्सिडरेशन इज ए void contract. Then next one is section 27 said that resident of trade agreements in resident of trade. Then the section 29 is agreement in resident of legal proceedings. Then wagering agreement is section 30, it is also void contract. Impossible agreement section 56. काही पैज लावली जाते बघा आणि पैजेमध्ये काय केलं जातं इम्पॉसिबल गोष्ट करण्यासाठी सांगितली जातात. मग अशा गोष्टीमध्ये सुद्धा काय आहेत ॲग्रीमेंट आणि सम ऑफ दी contract are invalid or void. An agreement to enter into an agreement in the future. So this kind of also the agreements is void agreement. Then contingent contract, what is it means? Is some of the a contingent contract is a contract to do or not to do something if some event collateral to such a contract does or does not happen. Section 31 Indian Contract Act has given the definition that what is contingent contract. For example, is given a contracts to pay B rupees 10,000 if B's house is burnt. This is a contingent contract. So some of the essential features of the contingent contract is given. The performance of a contingent contract is made depend upon the happening or not happening of a dome event. So the second one is the event on which the performance is made to depend is an event collateral to the contract. For example, where A promises to a pay B rupees 10,000 if he marries C, it is not a contingent contract. So now third one is the contingent event should not be the mayor will be of the promiser. For example, if A promises to pay B rupees 1,000, if A left Delhi for Bombay, it is a contingent contract because going to Bombay is an event, no doubt, within A's will, but is not merely his will. So this kind of is a contingent contract. Now, the meaning of performance, section 37 of the Indian Contract Act lays down the obligations of the parties regarding the performance. It provides that the parties to an contract must either perform or offer to perform their respective promises unless such performance is dispensed with or excused under the provision of this act or any other law. From the section 37, the performance may either actual or attempted. There are also two types of performance, that is actual and attempted. The one is actual when a party to a contract has done what he had undertaken to do, and there remains nothing to do to be done by him. The promise is said to have been actually performed, and the legality of such a party comes to the end. For example, A who is indebted to B for 1,000 promises to repay the amount after 2 months. In case A repays the amount on the due date, this kind of is a actual performance. So the next is attempted performance. Sometimes when the performance becomes due, the promisor offers to perform his obligations, but the promisee refuses to accept the performance. This is also called as a attempted performance or tender. For example, A promises to deliver certain goods to B. A takes the goods to the appointment place during the business hours, but the B refuses to take the delivery of goods. Thus, A has done what he has required to do under the contract. It is an attempted performance. In case of an attempted performance, the promisor shall not be held liable for non-performance as an attempted performance, or tender is an good as performing the contract. Section 38 of Contract Act provides where the promisor has made an offer of a performance to the promisee and the offer has not been accepted, the promisor is responsible for non-performance, nor does he thereby lose his rights under the contract. This kind of attempted performance is there. Now, the discharge of contract is there. So we will discuss about the discharge of the contract. So how the discharge is happened of the contract. So the according to the you can see here, discharge of contract is as per the performance is there, as per the mutual agreement is there, then the lapse of time and the operation of law, impossibility of a performance and breach of contract, breach. So these are the types where the contract is discharged. So one by one we will see what is it. So the first is a discharge of a performance. The most obvious or natural mode of discharge of a contract is by performance. The performance may be either actual or attempted, that we will discussed earlier. So here we can see the discharge of a performance. What is it? For example, we can say the A is getting the loan from the cooperative bank 1 lakh rupees, and after 3 years he has repayment the 1 lakh rupees to the cooperative banks. Then the performance of the that A party is fulfilled, and the cooperative banks is also satisfied with the repayment of the loan. So here the performance of the contract is natural and it is completed actually. So the performance of the completed. So contract is finished or discharged. So this kind of a example is there. So second one is a discharge by mutual agreement. Just as a contract is uh, created by means of an agreement, it can be terminated or discharged by a mutual agreement. If the parties to a contract agree to make a fresh contract in place of the original contract, the original contract is automatically discharged, and a contract can be discharged by the mutual agreement. So third one is discharge by lapse of time. The rights and obligations under the contract can be enforced only within a specific period of time called as a period of limitations. So the Limitation Act has prescribed the period of limitations for various contracts. For example, period of limitations for exercising right to recover the an immovable property is 12 years, and the right to recover a debt is 3 years. After the expiry of the limitation, this limitation period, the contractual right cannot be enforced. In other words, if a debt is not recovered within the 3 years of its payment become due. The debt becomes time paid by, and it is discharged by a lapse of time. So मुदत संपल्यानंतर ऑटोमॅटिकली काय होत असतो, तो कॉन्ट्रॅक्ट किंवा ते अग्रीमेंट संपुष्टात येत असतो किंवा त्याची समाप्ती होत असते. देन डिस्चार्ज बाय ऑपरेशन ऑफ लॉ, डेथ ऑफ ए प्रॉमिसर, इन्सॉल्वन्सी, मर्जर अँड मटेरियल अल्टरेशन. हे एक 4 प्रकार आहेत की ज्याच्यामध्ये दिलेलं आहे की डिस्चार्ज ऑपरेशन ऑफ लॉ होऊ शकतात. म्हणजे एखादा पार्टनरशिप फर्म असेल, so in case of partnership firms, some partners are occurred in death, so it times the contract is discharged. So insolvency is there, merger is there. Then next one is a discharge by impossibility of performance due to the some reasons which are beyond the control of the parties. The performance of the contract is become impossible. In such cases, the contract is discharged on the ground of impossibility of the performance. Section 56 is there of Contract Act provides that an agreement to do an act impossible in itself is void. So this rule is based on the principle that law does not recognize the impossible, and what is impossible does not create in any obligations. Then discharge by breach. If any parties refuse or fails to perform his part of the contract, a breach of contract occurs, and the contract is discharged. In case of a breach, the aggrieved parties and relieved from the performance his obligations and gets a right to proceed against the party at fault. A breach of contract may arise into two ways, that is the actual breach and anticipatory breach. This is the ways that you can discharge the contracts or agreements with the help of contract law. Now the breach of contract, and there are some remedies is there. So what is breach of contract? The Indian Contract Act 1872 states about the compensation of the for the law for the loss or damages caused by the breach of contract, as well as compensation for the failure to discharge obligations resembling those created by the contractor. So the breach of contract means a non-observance of the contractual obligations or failure to perform the contract. And some of the remedies means relief or solutions or redressal or to identify the losses and damages suffered by the both the parties. So that kind of a breach of a contract. There are two types of a breach. Breach occurring before the fixed time of performance has arrived, that is anticipatory breach. And second one is a breach occurred when the parties has failed to perform his obligations upon the fixed time of performance mentioned in the contract, that is actual breach. So these are the two types of the breach of contracts. Now the remedies for what we can say breach of a contract. If there is an actual breach of a contract, the injured party ultimately becomes entitled to one or more of the remedies. There are in total 6 types of remedies for injured parties against the guilty parties. So first is the rescission of the contract, suit for damage, suit upon quantum merit, then suit for specific performance of the contract, then a suit for injunction. So these are the 6 most important remedies are given by the Indian Contract Act for the overcome with the breach of contracts. So we will go for next meaning and definition of quasi contracts. So quasi contracts is based on the principle of equity, that a person shall not be allowed to enrich himself unjustly at the expenses of another. It means one should not accept or receive any benefit unjustly. So in the absence of contract, but on the principle of equity imposes obligations on the party or the persons, such obligations is called as quasi contractual obligations. It is the same to a real contract between the parties. Quasi contract is a not real contract entered into uh, by the parties intentionally. It reassembles a contract in which law imposes on obligations on a person to perform an obligation on the ground of equity. So according to Solomon, Solomon is one of the best author for in the respect of in the subject of law. There are certain obligations which are not in truth contractually in the sense of resting on agreement, but which the law treats as if they were. So this is the definition given of the quasi contract. Now the contract of indemnity and guarantee. The term indemnity means to make a good the loss to compensate the parties who has suffered some losses. The section 1 to 4 of Indian Contract Act define that a contract by which one party promises to save the other from losses caused by him by the conduct of the promisers himself or by the conduct of any other person is called as a contract of indemnity. The person who promises to make a good the loss is called the indemnifier, and the person whose loss is to be made good is called the indemnity holder. So the next is a contract of guarantee. According to section 126 of Contract Act, a contract of a guarantee is a contract to perform the promise or discharge of liability of third person in case of his default. A guarantee may be either oral or in written. So this is the difference between the contract and contract of indemnity and contract of the guarantee. So this PowerPoint presentation I will share with you, that you will study what is the difference, actual difference between the indemnity and the guarantee. Now, the contract of agency, when a person employs another person to do any act for himself or to represent him in dealing with third person, it is called as a contract of agency. The person who is so representative is it is called as a principal, and the representative so employed is an agent according to the section 182 of Indian Contract Act. The duty of the agent is to enter into legal relations on the behalf of the principal or with the third parties, but by doing so he himself does not become a party to make the contract to the contract, does not he incur any liability under the contract. Principal shall be responsible for the acts and activities his agents, provided they are not outside from of the scope of his authorities. So, agency may be created with the help of following ways: by direct or express with the appointment. So, the authority is said to be expressed when it is given by the words spoken or written. For instance, A by writing appoints B as a his agents. So by implications also is there, agency is implied when it is to be inferred from the circumstances of the case in the ordinary course of dealings. So by the necessity, under the some certain circumstances, one can act as an agent of another without the authority of the other. Such agency is also as agency of necessity. For example, a wife can for a necessary act as a her husband agent without any authority. So this kind of example is there. Then by estoppel, then sometimes an agent has no authority to act on behalf of the principal, but the principal by his conduct create an impression in the mind of a third person that the agent has an authority to act as on behalf of agent. So thus where a person by his conduct or by statement has led another persons to believe that a certain state of affairs exist. For example, a certain person is his agent. He is stopped from denying the first the fact of that statement is subsequently. So that kind of stop pay. So the ratification is there. Agency by ratification arises when one rectifies the or adopts the act of another who, without his knowledge or authority, acted as an agent. So this is one of these. Now discuss the what are the rights of agents. The first right is the right to claim reimbursement for expenses. Then the right to receive the remuneration, then a right to indemnification against the consequences of the all lawful acts, then the rights for indemnification against the consequences of acts done in the good faith. So then right of the indemnification of for the injuries caused by the principal's neglections or principal's ignorance is there. So the right of the particular lien. So these are the rights have been given by the Indian Contract Act to the agents, uh, those who are appointed by the principals in the businesses. So some of the duties are there. So first is to follow the instructions of his principals. This is the primary duty performed by the agent. That is follow the all the instructions and guidelines given by the principals. That is given under the section 211 of Indian Contract Act. Then the duty to act with the skill and diligence. So this is also given in the section 212. Then the duty to render accounts. So whatever the accounting accountability is there, it will be comes under the section 213. So duty to communicate with the principals. So the coordination and communication is there with the help of section 214. Duty not to deal with on his own account. Section 215 to 216 is though two sections is there which is related to the duty not to deal on his own account. So with the help of only principal's account, he will deal with anyone, the other parties. So sixth one is a duty not to delegate his authority. So this is one of the then duty to protect the interest of the principal or his legal representative in the event of principal unsoundness of mind or after his death. So duty to pay sums received from the for the principal. So these are the some of the duties are very important in the respect of contract of agency is required under the section various sections of the Indian Contract Act. So this is about the Indian Contract Act that we will discuss in this session. Thank you to everyone and all. And again, Happy New Year to all on behalf of me and also on behalf of Center for Distance and Online Education, Shivaji University, Kolhapur. If any doubts are there, you may ask on the WhatsApp group. Thank you, one and all.
Thank you, sir.
आले नाही